made reference to the fact that the other consequence of this offense is what has been described, and unless there is evidence to the contrary, I believed it because it's in the probation officer's report that the mother of the deceased suffered depression and stroke, and she has hardly healed. I've spoken to what the brother is said to be undergoing. This court, and I never lose out on anything, I try to get as much of in-depth of the material before me as I can, has been invited to take cognizance of the fact that the father of the deceased at one time said, I will let go. That did not form part of my record, because what formed part of the court's record is his sentiments as expressed in the brigade report, and that is what I will safely go by. But I'll be concluding with one or two other findings that could probably remove us from that mind thought that the father said, do not, vengeance is not mine. I also want us to just, in concluding, other than looking at the manner in which the offense was committed and the consequence or the impact of the offense, I took a bit of time to look at the character of the accused person. I have already spoken to how the probation officer describes him: aggressive and social personality, and concludes he has double personality trained. But let's look at what else this court was able to gather while hearing this matter on the character of the accused person. It was the evidence of the guards at Royal Park Estate, where he was staying, that he would not allow himself to be searched. He would brandish a gun and say, I work at State House, and just drive off. It is the evidence of the brother of the deceased that even during the hearing of this case, at one time, he blocked his car when the case was going on. And of course, you have heard from the IO, even when he was out on board, he was still involved. I'm not condemning him because there's no charge before me. But the court cannot avoid looking at this. Because at the end of the day, the question is this: is this a person you want to release back to the society? And these issues become extremely critical for consideration. Finally, this matter and the evidence adduced does not lead to a conclusion that this murder was accidental. That the perpetrator did not have an opportunity to think about the consequences of his action. It was intentional. It was not a defensive act. It was not out of provocation. It was planned, it was intended, and it was executed. And those who do not subscribe to Christian faith, bear with me. I do, and that's the only place I could make reference to. In the book of Job, chapter 1, verse 12 to 13, this is what is written. I think I looked at the Was it NIV? You can find out. Speaks to the same thing. This is what the Lord said to Satan. In my very final conclusion, join me in listening to these wise sayings on murder. 1. In the act of murder, one person's life ends, but countless number of lives are forever impacted. I will read again. In an act of murder, one person's life ends, but a countless number of lives are forever impacted. Secondly, murder leaves behind a trail of shattered dreams and broken hearts that can never be healed. Murder leaves behind a trail of shattered dreams and broken hearts that can never be healed. I have said the accused person before me is 33 years. The deceased was 28 years. Thirdly, the act of murder is a heinous crime that challenges the moral fabric of society and demands justice. And so it is not just a loss to the immediate family. Of course it is in the highest degree, but it's a loss to the society when one is killed unlawfully. And so, based on everything I have said, I have ordered that the first accused person before this court being Joseph Kuria Irungu alias Jowie, shall suffer death as provided for the offense of murder under section 204 of the Penal Code of Kenya. Unless that sentence is lawfully set aside by a court of competent jurisdiction. That is the order of the court. Thank you.